Business organizations. The rights and authority of corporate shareholders. The shareholders of a corporation have a responsibility to pay for their shares. Beyond that, shareholders have no substantive obligations. They're not required to manage the company. The corporate veil of protection limits liability for the shareholders. They're not obliged to pay the debts of the corporation. Creditors of the corporation cannot usually reach through the veil to require payment from the shareholders. Authority to manage the regular operations of the business is delegated to the board of directors. Shareholders lack authority to select, appoint or remove officers, or interfere in day-to-day operations. Shareholders do hold authority to appoint the board of directors, make suggestions to the board of directors, and decide certain fundamental decisions. A shareholder vote is always required for the appointment of directors. The appointment of the president, CEO, and other officers is delegated to the board of directors. But shareholders are able to make suggestions to the board for matters such as the nomination of officers and amendments to the bylaws. Although virtually all the decision-making power in a corporation rests with the board of directors, certain fundamental decisions require approval by the shareholders. These include such matters as the sale of the company, the sale of all or substantially all the company's assets, creation of new shares and options, appointment and removal of directors, termination and liquidation of the corporation. These fundamental issues have a direct impact on the value and marketability of the shares. The board cannot make such fundamental decisions for the company without approval from the shareholders. Shareholders have rights to access the books and records of the corporation. Some disputes have arisen in the past involving shareholder requests for lists of other shareholders. The typical scenario involves a political activist acquiring a share of a large corporation, then requesting access to the list of other shareholders in order to lobby for support in voting at an upcoming shareholder meeting. The courts in each state handle this type of case slightly differently, but the general rule is that registered shareholders have a right to the books and records, including shareholder lists, if the request is for a proper purpose, the request is in writing, and the deadline for delivery is reasonable. Generally, a matter in the interest of the corporation and its shareholders is now considered a proper purpose. Requesting the shareholder list in order to harass the shareholders or conduct fraudulent or criminal activity would not qualify as a proper purpose, and the corporation would not have to provide the list. Some states have set rules that the shareholder must hold a significant percentage of the shares in order to qualify. A shareholder holding a single share may not qualify for access to certain books and records in many states. State law is supplemented by the corporation's own bylaws when it comes to corporate law. Stockholder meetings are either regular or special. Regular meetings are scheduled in the bylaws, annually. Special meetings are usually called by the board of directors or a significant shareholder. The bylaws sometimes facilitate the calling of a special stockholder meeting by the CEO or senior officer. Notice is required for regular as well as special meetings. A letter or some form of communication must be sent to the stockholder ahead of the meeting and must forewarn the stockholder as to all the matters on the agenda. A quorum is necessary for a shareholder vote to be effective. The quorum is set at 50% in many states, but is customizable in the company's bylaws. The shareholder vote usually carries if it's passed by a majority of all the shareholders eligible to vote. So if a 51% quorum of eligible shareholders is in attendance at the meeting, they must all vote in favor of the motion in order for it to pass. It's not absolutely necessary for the shareholder to attend the stockholder meeting in person in order to cast his vote. The shareholder principal appoints the agent to act as proxy. and vote on the shareholder's behalf. The proxy then effectively steps into the shoes of the principal shareholder and holds the shareholder's powers. Proxy is a form of agency created by delegation of authority by the principal, the shareholder. Agency powers can be revoked when the authority is withdrawn by the shareholder principal and this is communicated to the third party. Agency and proxy powers can be irrevocable if subject to contract or agreement. It would be impractical for investors holding shares in several public companies to attend each stockholder meeting, and proxy voting is most common in larger, publicly traded corporations. As with other aspects of public stock trading, the SEC has set federal rules governing how proxy voting is orchestrated in reporting companies. Proxy voting services are now provided to shareholders online. The shareholder logs into a website and delegates authority to the proxy to vote his shares at the meeting. Supervotes and super-quorums of shareholders or director votes are supported by state corporation statutes. They're often restricted to small, closely held corporations, where individual shareholders have a huge vested interest in the corporation for their income and livelihood. Some states require the supermajority provisions to be defined in the corporation's articles. Others allow them in the bylaws. With a supervote provision, more than mere majority, a supermajority, is required to pass a resolution. Perhaps 80%, 90%, even 100% of the vote could be required to pass a resolution such as removal of a director or sale of the corporation. With a super-quorum, a supermajority of perhaps 80, 90, even 100% of shareholders or directors must be in attendance for the vote to be effective. Shareholders can enter into contractual agreements to vote their shares as a single block or according to some pre-prescribed arrangement. A voting agreement can enable collaborating minority investors to elect board members and have their voices heard on other important decisions. Voting agreements are now enforced in Delaware and model corporation states. Courts remedy disputes and enforce according to the contractual agreement. Shareholders are advised to explicitly specify how the court should enforce the agreement in one of the contractual provisions. Although voting agreements among shareholders are supported by several state courts, voting agreements among directors are void as against public policy. An exception is made, however, for narrow matters in closely held corporations. The hands of shareholders can be tied, but not the hands of directors. The board of directors must be free to decide matters as they arise and act in the best interests of the company at the time. Another method of enabling minority shareholders to pool shares and vote as a block is a voting trust. In this arrangement, the shareholder transfers the share voting rights into a trust. A trustee is appointed, and the shares held in trust for benefit of the shareholders, the settlers, and the beneficiaries. The trustee agrees to vote the shares according to the voting agreement. The right to vote is delegated to the trustee. Once the trust has been formed, assuming the trust was not formed under agreement that it could be terminated at will of one of the shareholders, premature termination of the trust requires agreement of all the participating shareholders, the beneficiaries. The shareholders lose their right to choose to vote while the trust is in place. Stock transfer restrictions are common in closely held corporations. With these restrictions, shareholders are not free to sell shares on the open market, as they might be if they were holding shares in a publicly held company. Shareholders in a small company may want to restrict who can become fellow shareholders. For example, they may wish to stop a competitor buying shares. Transfer restrictions are contractual and can be agreed in various forms. Sale of the shares to the corporation can be mandatory upon departure, at a pre-agreed price or formula. Alternatively, consent of the corporation can be required before the sale to a third party can proceed. It's common for the corporation or other shareholders to have a right of first refusal to acquire shares. These contractual arrangements are enforced by the courts today, even when they prevent the shareholder receiving fair market value. It's important, however, that the shareholder is on notice of the restriction. Notice is usually printed on the share certificate and noted in the share purchase agreement. A corporation that issued stock without any transfer restrictions can add such restrictions after the fact if it's able to get approval from all the shareholders. If some shareholders agree and some oppose the restriction, the corporation can find itself in a situation where some shares have restrictions and some do not. So corporations usually make provision for the transfer restrictions in the bylaws when the company is formed. They place shareholders on notice in the stock purchase agreement and place notice on the stock certificate itself. Shares in a public company are freely traded, but closely held corporations are often treated akin to a partnership. Courts often prevent minority shareholders being frozen out by the actions of the majority shareholders. When a majority shareholder sells shares in a closely held corporation, the minority shareholders have a right to sell alongside on a pro rata basis. Courts support the right of minority shareholders to sell alongside majority shareholders. Otherwise, the minority is left holding stock that's likely unsellable. In practice, co-sale rights are now often part of the contractual arrangement. Like a stock transfer restriction, and co-sale provisions are commonly seen in the stock purchase agreement. A controlling shareholder has unique powers and duties to the minority shareholders that restrict the controlling shareholder from leveraging its controlling position to take a benefit at the expense or detriment of the minority. In a leading case in this area, a corporation owned 97% of the shares of another corporation and essentially drained the subsidiary through entering into trading contracts between the parent and subsidiary that resulted in the parent draining funds from the subsidiary and failing to fulfill its contractual obligations. The parent restricted the subsidiary from filing a breach of contract suit against itself. This breached the duty the controlling 97% shareholders had toward the minority 3%. The parent leveraged its control position to take a benefit at the detriment of the minority shareholders. When it comes to selling control, the majority also have some duties to the minority. If the controlling shareholders sell control, under circumstances that they know or have reason to know the buyer will strip assets or somehow harm the company and the minority shareholders in the process, the controlling shareholders can be disgorged of the control premium that the buyer paid for the controlling shares. Courts are often asked to resolve situations of oppression by majority shareholders. Oppression can take many forms, but generally defined means the majority shareholders act in a way inconsistent with reasonable expectations of the minority shareholders. To resolve these situations, involuntary dissolution can be ordered by the court. The company's assets are liquidated, proceeds distributed to shareholders, and the corporation is then dissolved. Dissolution can be prevented, though, through a buyout at fair market value. The majority often choose to buy out the minority to avoid involuntary court-ordered dissolution. The disgruntled minority often uses an involuntary dissolution proceeding to trigger such a buyout of their shares.